Up next, we have a presentation from Dr. Roger Shiner, who says he came to Canada in 1964 on an 8-month contract and he never left. So please no intelligence in Kenny, because we'll get deported. Taught at the University of Alberta from 1964 to 1999 and moved to Kelowna after taking early retirement. He says he's married with 2 teenage daughters who are all talented musicians, so working from home is not a hardship on him. He's the author of 3 books and numerous journal articles. He teaches part-time here at UBCO in philosophy of law, political philosophy, computer ethics, and business ethics. Please join me in welcoming Dr. Rush.
Well, what I have to say follows nicely on from the previous talk in a couple of ways. One is that I'm sorry, Sally, you certainly don't win the prize for the oldest panelist. I was born in 1940. And I went through it all. Yeah? Whooping cough, measles, German measles, mumps, chicken pox. And I remember, my parents palpably afraid that I might get polio because people did get it. And, I'm very glad that my children, who, as you just heard, are quite young, haven't had to live in that world. I mean, the world they face has its own challenges, of course, but at least it doesn't have that one. And then the other way in which I lead on from what she was saying is really that I want to talk a lot more about, this regime, the legal regime within which all of this stuff takes place, intellectual property regime. And I'm going to talk about it, though, not as somebody who's in there on the ground working with it in the way that she was, but as a philosopher who's interested in these things from the point of view of what I would call the ethics of institutional design. I mean, here's a way that society is dealing with this process. Is it the right way? Does it produce the results that we wanted to produce? So, first of all, what are you talking about when we talk about intellectual property? And the point that I want to emphasize here is that it's creation of law. It doesn't exist naturally. We create the category of intellectual property, the idea of intellectual property, because of what we want to do with it. And what is intellectual property? Well, essentially it's a set of legal rules that define a variety of legal rights. Rights of ownership, rights of powers and procedures to acquire and transfer ownership, and things like that. There are lots of different forms of intellectual property. You're probably familiar with the idea of copyright. You write a song, you then control the distribution and publication of that. Patent is the form of intellectual property that's relevant to the production of pharmaceutical drugs, as Sally already mentioned. A patent deals with devices, widgets, gizmos, mousetraps, better mousetraps, stuff like that. So pharmaceutical drugs come under that. They count as that kind of invention. So why do we have patents? I was quite surprised when I first started working on this kind of topic to discover that the purpose of patents is actually contained in the US Constitution. The sort of familiar idea goes back to that. And they talk about the aim of the patent regime being to benefit society through technological innovations, sort of modern paraphrase of the idea. And that means that the patent regime, therefore, has to do 2 things at the same time, right? I mean, it has to encourage invention, it has to make it worthwhile for people to invent stuff, it has to make it worthwhile for, these drug companies to go through all of this and discover these things. But it also has to encourage making these inventions public so that they're widely and easily available for society to benefit from them. And these 2 things, on the face of it, kind of work against each other. But the idea is, there's a sweet spot in there somewhere where you're able to do both of these 2 things at once. And again, as Sally explained, the way that this is being done is that you give the inventor these rights. You give the inventor this legal protection over how what they invent can be used for a period of time. And then it stops and it becomes public, becomes part of the commons. So that's the idea there, is you're balancing these two goals. You're giving people an incentive to create, and at the same time you're making sure that at some point the benefit stops flowing to them and it all flows to society. Now, one thing I want to point out about this idea and the way that I've laid it out is that it's, in philosophical jargon, an instrumental argument. It's a means-end argument. So the end is that society gets the benefit from technological invention. The means is to create an intellectual property regime that gives people this protection. And if it works, fine, you don't fix it. But if it doesn't work, then you can fix it. Say what you're dealing with is a creation, a social creation, a legal regime, an artificial legal regime. Oops, didn't need to do that. Okay. So the question is, and now we're getting, I think, into the ethical issues. Does the current patent regime for pharmaceutical drugs work? That is to say, does it produce the benefit that society wants from it? That's the question that I want to take a look at in the rest of what I have to say. The industry doesn't want things to change, or if change comes, only for the better as far as they're concerned. As you know, if you read the news, the current Canadian government is engaged in free trade negotiations with the European Union. And one of the things that people fear, or at least people like me fear, is going to be on the table is the patent protection that Canada offers to pharmaceutical companies. A lot of the major drug companies are based in Europe, and the patent protection in Europe, I think, is longer, 23 or 24 years. And it may be that in order to get some things that Harper wants, he has to go with other things. So maybe the 20-year protection for drugs in Canada will change. But the industry would be very happy if it changed. There's activity going on at the international level. The World Trade Organization, the TRIPS Intellectual Property Agreement. Patent works by jurisdiction. Every country has its own patent regime, and if you invent something, you have to register it in every single country. This is an extremely elaborate procedure. The WTO wants everybody to sign on to the same scheme, but it's the Western scheme. It's the typical scheme from Europe that they want everybody to sign on to. It's not at all clear. So countries like India, who operate with a much less industry protective scheme, they're being encouraged to sign on, and they don't want to do that. There's no restrictions, or very little restriction now under the current Canadian regime on what are called Me Too drugs. Right? You make one tiny little your patent starts to run out, you tweak the drug one tiny little bit, and whiz bang, we got a whole new 20 years. So it's perfectly legal. A lot of people think now, no, maybe it shouldn't be legal. And then there's very little acknowledgement of ethical duties to help the poor. The industry would rather that the whole thing is based on entirely voluntary giveaways. We decide to do good. That's the status quo. So the problems that you find with this, say, is that you get an emphasis on lucrative so-called lifestyle drugs. You get the patents artificially extended. You get them extended by what I'm rather prejudicially calling foot dragging through litigation. It's generally recognized that this 20 years can be extended to 23 or 25 just by various kinds of challenges to generic drug manufacturers that are legal. Big problem with so-called orphan drugs. drugs to treat or vaccines to prevent diseases that affect only a few people or only poorer people. Problems of limited governmental resources in the developing world. Drug company says this vaccine or this drug costs $10,000, take it or leave it. But you're a poor country in Africa, what are you going to do? Intellectual property rights don't exist in an ethical vacuum. Because we think of them as rights, then we think, oh my gosh, they're these terribly powerful things. We all love rights. We all think rights are really, really strong. But they're just pieces of law, right? That's all they are. There's other rights that exist as well that are applicable to this situation. You know, a right to stay alive, a right to health, a right to health care, a right to have access to essential life-saving or life-protecting drugs. And say some philosophers think that these go down the chain. If you grant this, then you've got to grant that. If you grant that, you've got to grant that, and so on down. Rights imply duties. Fairly basic ethical principle. If I have a right to something, healthcare for example, then somebody has a duty to provide me with healthcare. Now, how that plays out in any particular actual social context at any particular actual time, of course, is going to be an enormously complex issue of public policy. It's an ongoing matter of debate in Canada right now, doubtless will be even more so after the results of the Alberta election Monday. It's just all the time we're thinking about this. And I don't have any quick fixes, and I'm not even going to try and get into that morass. So yeah, I acknowledge all of that. I mean, speaking in the large, obviously duties fall on the industry itself. It's going to be heavily involved in delivering health to Canadian citizens. Duties fall on the government, and duties fall on us ourselves. And that's been hinted at in several of the papers so far. Right? If we don't vaccinate, we affect the pool. You can look at that, say, in terms of the duty. So again, it's a complex question, and I'm going to, what I have to say really only looks at a very small part of it. Right? Think of the proverbial drowning child. Right? When do we have a duty to attempt to rescue a child drowning in a pool? Well, the received wisdom among philosophers anyway is pretty much that it depends on these four conditions that I've listed here. That you have the physical ability to do so. If you're in a wheelchair, you can't jump into a pool to save a drowning child. You have the expertise, if that's necessary. You have proximity. If you're 400 yards away and somebody else is 1 yard away, that makes a big difference. And you factor in the cost to yourself. Am I risking my life, or am I risking merely dirtying my new designer jeans? That kind of thing factors in. The pharmaceutical industry fits this profile when it comes to its obligations to deal with health problems. It has the physical resources. Pharmaceutical companies earn billions of dollars. It has the expertise. It has the scientists, or it employs the scientists, or it funds the scientists. It's worldwide, has proximity. In context, the costs are minimal. Sally did explain how development of some of these drugs costs an enormous amount of money. Yes, it does. Development, in other words, doesn't cost so much money. They also have the lifestyle drugs which bring in billions of dollars without being related specifically to the sorts of diseases that are being talked about today. The industry, in fact, has two specific obligations. What I'm calling, and I'm borrowing actually not only this terminology, but some of these ideas from a business ethics professor in the States called Richard DeGeorge. He talks about a production obligation and an access obligation. Now, an obligation actually to produce essential life-saving and life-protecting drugs, and then an obligation to ensure access to them. Say the production obligation is fulfilled just by producing it. But if it's priced very high, unrealistically high, from the point of view of the market power of the people who are going to need it, then you're not fulfilling the access obligation. So how can industry meet these obligations on the assumption, which you may or may not accept, that it's not properly meeting them right now, particularly in the developing world? So, as I've said already, the patent regime is an artifact. It can be changed. Governments can make changes to patent regimes. Governments have the responsibility to do that. It will take a lot of citizen pressure, which is where our responsibility comes in. The industry itself can change the way in which it does business. And I put on the board two dramatically different examples. On the one hand, you have the pharmaceutical company Aventis, which cooperates extensively with governments and NGOs in sub-Saharan Africa, creating public and private partnerships for delivering vaccines, still does so in a way that's economically profitable to itself. Or on the other hand, you had GlaxoSmithKline, who produced an AIDS vaccine, and the South African government wanted to override their property rights in order to make sure that the vaccine got to the people who needed it in South Africa, and GSK sued them for doing that. In the end, they lost. They had to back down from the lawsuit because of public pressure, and it didn't do the reputation of the company any good at all. But that's the difference between a cooperative and a confrontational approach. And from the ethical point of view, the cooperative approach is much to be recommended for the industry. Another idea, and I have to thank my business ethics students at OC, this term is just finishing, for bringing this up when we were talking about these issues in class, because I hadn't heard of this before. And this is the idea of a patent pool, where you voluntarily license the use of your patents to one central place. And then these patents can be accessed there by anybody, and the fee for the licensing gets rebated by the pool back to the manufacturer. And if you imagine that you're a government in a developing country where you don't have a lot of resources, what this patent pool idea gives you is one-stop shopping. You don't have to go round dealing with every single manufacturer and negotiating with every single manufacturer. You can work through the patent pool. And say, I don't know a lot about it, but it was an idea that was thrown up, and say, it looks attractive. So that's what I've got to say. And say, going back to the story on the board, say, that's taking place in an ethical context, it's taking place in a legal context, and what I've been trying to do is just to stand back from that context and look at it from a broader ethical perspective. Thank you.